Consumer Counterpoint, your video cast about consumer issues, litigation, class actions. I'm Christine Argentine, one of your co-hosts. I'm in the Cypher office in Chicago.
And I'm Paul Ivanek, also a co-host in the Chicago office. And today we're going to talk about a recent decision where the Supreme Court of the United States has agreed to take on the critical threshold question of what is a consumer under the Video Protection Privacy Act, the federal statute.
Yeah. So let's talk a little bit about that statute first, because I don't think we've really covered this one that much before. It's similar. It trended around similarly around the wiretap statutes.
Right. So I mean, enacted in 1988 in response to Justice Bork's rental history being released during his Supreme Court nomination. And so in 1988, so in 1987 that occurred, 1988 the statute's enacted. And it's really designed to prevent or prohibit a videotape service provider from disclosing information outside of the ordinary course of business, and
Right.
Without having consent, and in doing so, there's a $2,500 in actual damages if there's no consent.
Yeah, and it's really targeted at someone's video viewing habits. So in the instance of Judge Bork, right, he went to a video rental store, remember those, and rented videos, and then that list of what he had rented or his family had rented was released. But now, over the past few years, we've seen this kind of applied in the pixel context and the
Right.
tracking technology context. So what we're seeing is plaintiffs' bars are alleging that if you have tracking technology on your website and you have videos on your website, if that tracking technology is capturing what video a user watches and then transfers that to a third party,
Right.
that's capturing of someone's video viewing habits without their consent.
Yeah, and it kind of goes back to something we've said so many times on this video cast of just old statutes, new technology, and the plaintiff's bar just trying to find a creative way to say, aha, this 1988 statute regarding video rental history somehow now applies to 2026, and in the last 5-6 years of tracking technologies or
Right.
just viewing videos on their website, that just might be placed on the website. And so, obviously over the last few years, we have seen some decisions. We've seen some conflicts of decisions from the circuit court, and so maybe we just dive in a little bit to that as well.
Yeah, I mean, what's interesting about the Video Privacy Protection Act is that it has really specific definitions in it,
Right.
unlike some of these other statutes
Right.
we've been dealing with. And one of those definitions is the definition of consumer. And so the way the VPPA defines consumer is a renter, purchaser, or subscriber of goods or services from a videotape service provider, which also has its own definition.
Right.
In the context of, right, the days when there were video stores.
Pretty easy to figure that one out.
That's
Yeah.
right. A purchaser, a subscriber, a renter, right? It's easy. Now, what we've seen is this idea of a subscriber of a website or a subscriber of a newsletter through a website trying to fit that definition, even if that subscription has nothing to do with the videos available on that website or the video services that company may offer. And so, as you said, there's been a circuit split.
Right, I was just going to say,
Yeah.
and that is really the point where we're seeing these circuit splits, and I think we've got, the Second and Seventh Circuit kind of taking this broader approach as opposed to the Sixth and the DC Circuit, taking this narrower approach.
Right. Yeah, so the Second and the Seventh Circuit have essentially said any subscription will do, right? If you're a subscriber to the website in some way or a subscriber to
Right.
even the company's goods and services in some way,
It just attaches to
that meets that definition, move on to the next element of VPPA.
Right.
But what the Sixth and DC Circuit says is it's a narrower definition, and there has to be a direct connection between the subscription and the video services.
Yeah, and you can see where that type of split will get companies, just abused by the plaintiff's bar.
Right.
And where do we want to file these lawsuits? Where do we think we can at least say, aha, here the Second and Seventh Circuit, you've got a problem here. Whereas we see like the Sixth and the DC Circuit saying, no, you're going to have to show a little bit more. we're going to see. I mean, we see the
Yeah.
filings going in those circuits that are taking a broader view.
Yeah. And you can see with the definition of consumer where these courts are coming from, right? Because it says, a subscriber of goods and services from a videotape service provider, but it's not really specific, because now you've got companies that have lots of goods and services, some of which may be audiovisual related, some of which may not. And so it just, right, again, old statute, new technology.
Yeah. They weren't
new,
contemplating
right.
this type of technology when it was enacted almost 20,
Right.
more than 20 years ago.
Right. So on January 26th, the Supreme Court granted certiorari on a Sixth Circuit decision. Mm-hmm. So in the Sixth Circuit decision, the court took the narrower view and dismissed the case, saying your subscription to this newsletter doesn't make you a consumer for purposes of VPPA.
Right.
So the plaintiff in that case appealed. What's interesting is that this particular plaintiff was also part of another case where it was in a circuit that took the broader view, and the case was the plaintiff was declared a subscriber for purposes of VPPA, and the defendant appealed. Mm-hmm. The Supreme Court didn't take that one up.
Interesting.
But now they're taking this one up on the other side of it. Maybe they weren't ready to take up the issue back then. Or didn't think that
it was going to be as much of an issue, and now fast forward to 2026, right. And it's like, all right, now we're looking at the other side, so maybe we just need to make some finality here.
Yeah.
On this issue.
Yeah, and I really think it will help, right? There's
Mm-hmm.
a lot of cases pending out there under the VPPA, a lot of cases still being filed under VPPA with this kind of theory that subscribers of anything are, consumers, and so you can kind of pull in all sorts of types of websites in that regard. And as you said, really could lead to a lot of forum shopping and cases with massive exposure being successful in one circuit and not successful in another.
Exactly. So, I mean, that's going to be key. So I think in terms of timing, so the Supreme Court has agreed in January 2026 to take it on. What are we looking at in terms of maybe anticipated oral argument or decision?
So the argument will likely happen in their October term, which means we'd be looking at a decision in 2027.
Yeah.
Right? So not terribly soon. But it is nice to see the Supreme Court take this up, right? It is something that has been cases that have been litigated for years, and there's been a lot of uncertainty around how to define these terms, how to apply the technology. We're similarly starting to see some appellate courts take up issues in California on the CIPA. So I think the higher courts are starting to recognize there's a real need for clarity on a lot of these issues.
Yeah, I mean, you look at kind of just the logjam that some of these certain courts, California, Illinois with BIPA, I think once they've realized that some of these, older statutes being applied to newer technology needs a little clarity, maybe can kind of clear up some of that logjam and just avoid kind of these mass filings that we're seeing under some of these statutes that are arguably being abused.
Yeah, agreed. So we'll keep everyone posted as we see more appellate decisions, more Supreme Court action, but just wanted to give an update on this quickly.
Awesome. Thank you.